Number 69, Brookford versus New York State Division of Housing and Community Renewal. Counsel.
Good afternoon, Your Honor, and I'm Victor Kovner, attorney for Brookford, the appellant in this proceeding, and with the permission of this court, would ask to reserve 3 of my minutes for rebuttal.
You may, sir.
Thank you, Your Honor.
Welcome.
We believe that the resolution of this appeal turns on the language of the statute and the clear legislative history. And it is the statute and legislature's intent that the Division of Housing and Community Renewal has subverted by rewriting, in effect, its key provisions. Now, the statute has 4 relevant clear requirements. Annual income shall mean federal adjusted gross income as reported. The income shall be of all persons, except for non-family employees, who occupy the housing accommodation as their primary residence. The income shall be subject to verification by the Department of Taxation and Finance, not the DHCR, and there shall be no disclosure of any income information.
Look, counsel, isn't the federal, excuse me, I'm over here.
Yes, I'm sorry.
That's all right.
Your Honor.
That's okay. In the federal joint statement and aggregation of income, so don't you have to disaggregate the income to know the income of the person who's using the apartment as their primary residence?
You do not, Your Honor. Joint income under federal and state law, that is, joint income reported on a joint return, is indivisible. It is ascribable to both parties.
But indivisible for federal purposes. I'm talking about for our state purposes, no?
No, not for state purposes, Your Honor. And I think it's important to note that the legislature, in its wisdom, put into the language of this statute a rather technical term for the definition of income. You could define income in many ways. They chose to put in federal adjusted gross income as reported. That has specific meaning in federal and state law, and they did it for a very good reason.
But even for the purpose of the federal tax law, if somebody moves out of the household within the 12 months preceding, you can actually amend your return, right, and disaggregate it. I think that's
it's
USC
possible.
6015.
It's certainly possible to amend one's return, and there is legislation on who is a primary resident or and who is not. There are a number of, and as to that issue, not the tax question, the Department of Housing and Community Renewal has expertise and does resolve it. It's not an issue in this case because all the parties agree there was but one primary resident in the relevant date, which was 2005, and that was Ms. Friedman.
What if this couple separated, and she lived in one apartment that was rent regulated, and he lived in another apartment? So they would both have to include, and they filed joint returns, but they clearly had separate primary residences. So they would each have to claim the aggregate for purposes of luxury rent deregulation?
Assuming both are in regulated apartments, I think the answer is yes.
So how does that comport with the intent of the legislature?
The reason the legislature chose federal adjusted gross income as reported, which is the amount she reported, Ms. Friedman, is that it was the simplest way to administer this system, ease of administration. DTF could go, get the name in the apartment, just look at the tax return, look at the AGI, and report back whether it was above or below the threshold.
So if here instead they had filed separately, married filing separately, we wouldn't be here.
Absolutely right, Your Honor. That's the point, and that's a decision that Ms. Friedman made with whatever accounting or other advice available to her to file jointly. Many people do, and many people don't.
But your tax accountant isn't necessarily, figuring out also. And by the way, this is going to, bring you over the income threshold for rent stabilization.
The answer is, Your Honor, there are numerous cases cited in these briefs in which the courts have said it's the federal adjusted gross income as reported, and that's it. They don't look beyond it because that's what the legislature.
The cases say that, but the case.
Occupants? I'm sorry.
No, you go ahead, Judge. You go ahead.
I was just.
I'll go. Why do you think they use federal adjusted gross income as reported on New York State income tax return? I mean, it's a strange phrase, right? They could have used federal adjusted gross income. Why did they use that terminology? It seems to mean something different to me.
Because there are many ways you could categorize or define income, and there are lots of. It was the simplest and easiest.
Why not just use federal adjusted gross income?
That's what they did do.
No, it says federal adjusted gross income
As reported?
on why?
I think the as-reported phrase is important, should not be ignored, because that was reported to the agency that would determine it, the Department of Taxation and Finance.
It's a way you ensure you're looking at limited documents, right? You're only looking at the state documents because that's what you're trying to figure out. But I want to get back to the federal tax because I'm a little confused by your argument, and you'll correct me if I'm, and it would be no surprise if I'm misunderstanding the federal tax law. But I thought the federal tax law that you were relying on is referring to joint liability, but recognizes that it's income that's aggregated for purposes of filling out the form. The joint part of it is the tax liability.
It's not simply liability, Your Honor. It's the Treasury regulations state unequivocally, although there are two taxpayers on a joint return, there is only one taxable income. And that was a choice that was made for whatever reason to go that route
Yes,
and
but
not
that's
go
what
the
I'm
separate
saying.
route.
When you say taxable income, isn't that saying that the liability for federal taxes is based on an aggregation that comes up with a number that's considered the taxable income?
A joint income is not divisible as a matter of law for any purpose. One cannot apportion it. It is.
You know what I wonder? It seems to me that DHCR, the way I understand this, demanded the supporting tax information from the Freedmans after initially making an error in their earlier decision. Is that correct? That's the way you understand the record?
It is, and of course, in doing so, they violated the statute and their own rules.
All right. So the question would be then, who can object to the Freedmans supplying tax information to DHCR? It seems that only the Freedmans should be able to object to that. I don't understand the basis of your objection since it's their tax information.
Well, I think we have the standing to argue, as we do, that their conduct violated the statute.
Since in this case, to some degree, we're required to look at the legislative history and the purposes and intent of this behind it. So I want to step a little bit behind it. I'm not arguing your standing here. I understand that. Let's assume you have standing. But the purposes and intent would, of course, would be to protect and to limit government's intrusion into a private person's tax information. It would seem to me that the Freedmans would have that right, not Brookford.
Actually, Judge Fahey, I do want to correct your version.
Fahey.
They were asked by DHCR to provide all this information, the W-2s, the 1099s, the tax transcript. They sort of made it worse than other, and they computed them themselves, even though they've acknowledged don't have the expertise to do it.
I accept that.
And the Freedmans complied, but that very process is the very process the legislature chose to avoid.
Do you understand my point? What I'm wondering is, they're their tax reforms information. They give them over to DHCR. They don't object to giving that information. On what basis could that possibly harm you for them to give fuller information?
Because it invited, or more than invited, they asked the relevant agency asked them to participate jointly in a violation of the statute, to do something that they weren't asked to do. They had no jurisdiction. It was a extra legal, ultra vires assumption of authority to pursue their own judgment that they could apportion it because that was, for whatever reason, they thought was better, as opposed to, if they thought there was some sort of gap in the statute, going to the legislature and asking them to address it.
I see. Thank you.
I see my red light is on, and I want to keep my 3 minutes. Thank you, Your Honor.
Counsel?
May it please the court, my name is Sandra Joseph, and this is Anita Shia, counsel for DHCR.
Counsel, are there any scenarios under which joint income would be divisible?
Yes, under New York State tax law, even though the parties filed a joint tax return, New York State tax law has various scenarios where, let's say, if you file a joint tax return and one of the parties is a non-resident, then they'll file a separate return.
What about child support determination?
Yes, under tax law 171, which was enacted at the same time that B was for high regulation, actually, it was the same measure. What tax law 171 says and what the rent control statute says is that it's using this, it says for these purposes. It's not saying it is the federal tax law. It's saying this means, or we're going to use this measure in order to determine income. And to answer another question, why they're using federal tax law as reported on the New York State income tax, this is kind of interesting because federal tax law, federal income on a New York State tax return can be higher than the New York State income. Because let's say, even if you file single and you have out-of-state income, that's included in your federal income tax return, and it's not included in your New York State income. The statute sought that it's only the occupant on the day the ICF is served or is using the premises as their primary residence. There's nothing in the legislative intent that said, well, if you file a federal tax return jointly, you will therefore have to report that income. It's only the income. It's not the liability. The owner is trying, or the appellate is trying to import the liability into the rent control statute. And there's, in this case, you know, the tenant in this case wouldn't have known that she shouldn't file a federal joint tax return, as her husband was just going into the nursing home, and there he subsequently died. He clearly wasn't in the apartment at the time that the ICF was served.
So what's the basis for DHCR to ask for this information or to demand it?
Well, actually, DHCR really didn't violate the statute. It said,
Okay, then tell me what the basis is.
the basis is that, to be quite honest, they wanted to verify. DTF came back with a result that the tenant wasn't over income based on the percentages that
So in other words, you're saying it wasn't expressly prohibited for them to ask for it?
Exactly. Do you want the exact section?
No, I trust you.
Okay, thank you.
I trust you.
Counsel, mindful of the important privacy concerns that are at stake, how do you apportion in a way that is transparent enough to allow a landlord to have a meaningful challenge?
Unfortunately, just like on a tax return, it's as reported. You know, the tenant reported her percentages, which has been on the ICF form for almost 25 years. There's been Section 7 that says, tell us what percentage, and this form was designed by DTF. It wasn't designed by DHCR. And it says, tell us what your percentages are. Just like on a tax return, it's all self-reporting. It's not,
So you're saying if they fraudulently reported AGI on the federal tax return, then the owner has no basis to challenge that either?
Exactly. And I mean, in Section 7 on the ICF form, they do affirm that these are the correct percentages. The only thing DHCR sought to do, because this was the first time DHCR was faced with this situation, they wanted to verify DTF's findings. They wanted to verify the tenant's percentages, and under the statute where we could ask for the information, we did ask for an IRS transcript. While DHCR will concede it has no expertise, the transcript that we received from the IRS picked the things off the joint tax return that was ascribed to the
Can I
tenant.
ask, and you're correct if the premise is flawed. So the husband is there part of the year.
No, he wasn't there at all.
At all?
At all. He was in the nursing home.
Is there any gross limit on income at all? I mean, that certain adjusted gross income, this just doesn't apply at all?
In what scenario?
So if you have $5 million in adjusted gross income total, but one spouse earns $40,000 of that,
There's no limit. It's almost like the case of Glenbrier versus Lipson, where the tenant had no income and the husband, trying to evade New York state tax laws, moved to Florida and claimed a homestead rebate. It's the same situation. You can have one that earns all the income and the other one that earns nothing.
and you could get this benefit then. So if it was the spouse of Mark Zuckerberg or something, and just a total
Exactly, and he
example.
moves to Florida.
And he
his
was living in Silicon Valley, and someone like that, and the spouse is living in New York and has $50,000 in income, that's what you would count.
Exactly.
So
That's
doesn't
what
that seems like there's something wrong with that calculation?
That's what the legislature.
If you have like $2 billion, and like, why would you qualify for this?
But that's what the legislature saw fit in this statute, and also in tax law 171-B.
Okay, can I just clarify the dates, because now I'm very confused. So what period is the ICF covering?
I can't answer that off the top of my head. I'd have to look. The ICF is the date, the operative date for that is the date that it's served. He was not in the apartment.
Because he had left the prior year.
Yes.
Okay.
But
And then
is
the tax form that you're looking at is for what tax year?
I believe it was for the prior year.
It was '04 and '05, I believe.
Yeah, I think he,
So that, I'm sorry.
I'm not 100% sure.
Okay, so you-
Maybe the tenants' council can answer
Okay.
that for you.
Thank you, counsel.
Good afternoon, Your Honors. May it please the Court, my name is Robert Sokolsky from Sokolsky and Zakaria. We represent the respondent, Margaret Chouette Friedman.
Can you clarify this issue about
Yes.
the ICF and the tax years?
First of all, the tax years, it was an ICF that was served on April 27, 2006. The backwards looking is 2 years, so it'd be 2004 and 2005 that would be the years in question. And just in the beginning of 2005, March 21st, 2005, Cy Friedman moved out permanently from the apartment. There are affidavits that we submitted to DHCR that confirm that his move out was always considered to be permanent.
But what
And
if
then
he
he-
moved out on December 31st, 2005? No difference?
No, it wouldn't make any difference because the date that DHCR looks at to see whose income should be included is the date that the landlord chooses to serve the ICF upon the tenant, which didn't happen for another year until April 27, 2006. In fact, by the time they had served the ICF, Cy Friedman had moved from the nursing home into hospice, where he died that following November.
No, I'm sorry, so what year does he pass away, 2005, 2006?
2006, November 2006.
And he moved into hospice?
He
March?
moved into hospice on March 1st, 2006.
Okay.
So it was before even the ICF was served. Not only was he in nursing, but he was moved out to hospice. There are a couple of phrases there are a couple of things that concern me, and I know my time is brief, so I might speak a little bit fast. The tenant was not directed to provide anything but the ICF form and the copy of her tax label on the state form, which is what DHCR does. I with my client voluntarily provided backup information in order for DHCR to review how we did the proportions of income, the apportionment, and to say, okay, well, you did it right. Okay? In fact, we were off by 2% only because there was some interest that
What
my
you're
client...
saying is DHCR didn't demand it, that you provided the information.
Absolutely, voluntarily. In fact, all my papers state that from the very beginning, voluntarily. So I took a red confidential stamp. I said, don't give it to the landlord because he's not entitled to it. But it's like an in-camera review. And you want to review it? Review it. We actually were attributed more income to my client than necessary because she couldn't find two small interest statements. So she wound up with 34% instead of 32% apportionment. I don't think we're properly here on this question, because they have not, DHCR has not done anything but act in the statute. This was a voluntary action. This is not a question of whether or not DHCR can demand things. And by the way, they can, because the statute, the deregulation statutes state that if DHCR can't figure it out, if they don't get an answer, or if they can't figure it out, they can ask for more information. There is nothing secret about a tenant's income, Your Honors, unfortunately. If you ask any tenant that has NYCHA housing, Mitchell-Lama housing, an HDFC co-op, or Section 8, they have to every year, they have to verify their income.
So
they
is
have
the
to
purpose
supply.
then to keep the owner from having access to this information? Is that the purpose of the rules limiting what can be required?
Yes, yes, because the information, well, yes and no. The information on a tax form itself, because it has the form, right? We have 697 of the tax form of the tax law is very strict in what someone provides to the taxing authority, and we want that to be candid, so we protect it. Okay, so we're very stingy on what happens, but just on that form. When you ask about someone's income, tenants certify their income all the time for low-income housing. They do that every single year. They have to tell the landlord who's managing the property what their income. There's nothing secret about this. And the law states that it is the adjusted federal gross income. And I know I heard the phrase, this is my second concern, as reported. It's not as reported. As reported on your New York State tax form. And that's a signal. That's a signal that the legislature did not intend to import the whole body of federal tax law into New York State housing law. I see my time is up, so unless Your Honors have any questions, I thank you very much for your time.
Counsel?
Yes, just very briefly. First, the most important point is the statute expressly prohibits the administrative agencies from asking for this information. The statute says, shall not require disclosure of any income information other than whether the aforementioned threshold has been exceeded. So neither DTF nor DHCR could.
So let me ask you this. Is the question then whether or not they asked for it or whether or not they can see it? Let's assume they didn't ask for it, that counsel is correct and it was voluntarily turned over. Are you saying they can't see this information?
Yes, I am, Your Honor. That was what the legislature had in mind, to make this a simple check to protect tenant privacy. Just look at the federal AGI as reported on the tax return. Is it above the threshold or no? A couple of other points, just very briefly.
Even if not seeing it might result in something that undermines the statutory intent, which is to only count the income of those who are using the apartment as their primary residence?
The answer is there are a whole series of cases in the briefs, Your Honor, in which the courts have said the statute makes the federal AGI as reported determinative. They're not going to look beyond it, even though there may be some other income anyway, someplace, some other wealth, corporate income, whatever.
Yes, but that would inure to the landlord's benefit, right? Because it might increase the income. But if she wants to show that the actual income falls within what the statute permits, wouldn't it undermine the goals, the larger goals?
It does, Your Honor, because it undermines that there should never be an audit, that no one should be asked, or people's privacy should be respected as to this detailed information. Just very briefly, you could either as to some of the points from my adversary, you could either file a joint return or a separate return, but not both.
And what's the tax policy in New York State that gives you the different treatment for filing jointly than filing separately? And is that inconsistent with separating the income?
It's not inconsistent. In New York State, it's joint and indivisible across the board. That's the nature as.
No, but I think I'm not being clear. So you get a different rates and different applications of tax laws filing jointly than you do from filing individually if you're a married couple, right?
Yes, you do.
And-
And in fact,
But can I just
Yes,
finish?
by all means,
What's
Your Honor.
the policy behind that, giving you those rates for filing jointly as a married couple? And is that in any way inconsistent with splitting the income out for these purposes?
you get a lower rate if you file jointly. The government, both federal and state, wants to encourage you to file jointly. You get other benefits. This tenant chose to take those benefits and not give them up. I don't know how large they would be, not give them up by filing separately. And I think my red light is on, and I think I'm going to stop unless there are further questions. Thank you very much, Your Honor.
Thank you, counsel.